Thank you, Your Honor. This hearing is in the matter of case number CFI 030-2022 before His Excellency Justice Ali Al-Madhani. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Norton Rose, Fulbright Middle East LLP. Lead counsel is Mr. Tom Montague Smith QC. The first defendant is a litigant in person represented by Mr. Axel Manis. The second defendant is represented by Galadari Advocates and Legal Consultants. Lead counsel is Mr. Sergish Delivka.
Thank you, Sahla. Thank you all for appearing before me today. We are apparently here to hear the two applications for de novo review contesting the speedy dealing with the set-aside application in regard of the stay decision made by Justice Maha Al-Muhiri earlier. To take it in order, I mean, we supposed to deal with the applicant who brought the de novo application, and maybe we can start with Mr. Delvica. And Mr. Delvica, I don't expect you to be long. I'm fully aware of your application. I'm aware of your situation. I have read all of your submission in this regard. And I understand it's what stands today is the matter how urgent we should hear the claimant application for set aside. It's whether tomorrow or another day. And if you can go short, please.
Thank you, Your Excellency. May it please the court. My name is Sergey Delevka and I appear for the second defendant. I'm a practitioner registered with the DFC Court Register of Legal Practitioners. My limited rights of audience, Part 2, at the DFC Court are currently provisional, and thus in absence of the registrar or senior legal officer attending this hearing, I seek Your Excellency's permission to proceed with my submissions on behalf of the second defendant.
You have my permission. Please proceed.
Thank you. Your Excellency, this hearing is limited only to the defendant's individual applications for de novo review, seeking to set aside or amend the registry directions of the 6th of July 2022 sent in response to the claimant's letter of the 6th of July 2022 requesting that its set-aside application of 4th of July 2022, the set-aside application, be heard at an expedited hearing. The directions were sent only 23 minutes after the claimant's 3-page letter request to the registry. The second defendant was not afforded an opportunity to comment on the claimant's request before the directions were issued. All of the second defendant's subsequent comments concerning the directions, namely the lack of urgency or importance of the set-aside application, the unreasonable deadlines set within the directions, and considering the lack of noted urgency and significance, the absence of any need to hold a very costly and time-consuming oral hearing were disregarded by the registry. As a result, the second defendant had no other options but to file the de novo application, seeking to set aside or alternatively amend the directions. The registry, however, compelled the parties to comply with the standing directions, which required the second defendant to file a reply on the set-aside application, notwithstanding the second defendant's pending de novo application. Claimant submits that this was prejudicial to its de novo application. The second defendant continues to rely on the contents of its de novo application and its response to the claimant's reply on the de novo application, which were filed in a timely manner. In summary, the claimant's set-aside application, it is submitted as not urgent to justify a hearing on an expedited basis or significant to necessitate a costly and time-consuming oral hearing. There is absolutely no good reason why the claimant's set-aside application cannot be or should not be determined on paper. The second defendant notes the claimant's assertions, however, that it was not afforded an opportunity to file and serve written legal submissions pertaining to its set-aside application. In this regard, the second defendant is content that the parties, namely the claimant and both defendants, be granted an opportunity to file and serve simultaneous written legal submissions in regards to the set-aside application by 4 p.m. on Tuesday, the 26th of July, 2022. Accordingly, the second defendant respectfully requests that its de novo application be granted, principally in accordance with the relief sought therein, and that the parties be directed to file and serve simultaneous written legal submissions in regards to the claimant's set-aside application by 4 p.m. Tuesday, 26th of July, 2022, and that the set-aside application of the claimant be determined on papers only. This concludes the second defendant's submissions. Thank you.
Well, I see, Mr. Delifka, I think so. You want two things. You want to drag the hearing or to delay the hearing 4 weeks, and then you want it to be dealt with on paper. That is your request, isn't it?
The principal request by the second defendant is that the set-aside application hearing should not happen at all. The principal position of the second defendant is that the set-aside application should be determined on papers only. There's nothing within the set-aside application that would justify having a costly and time-consuming hearing, considering the preparations involved. And we've dealt with each.
Wait. Given the fact this is a straightforward, a simple application, even though it's a set-aside application of the judge, so the matter will be dealt with again. And understand this will not be seen by the Court of Appeal, but with the same court, because the manner where that decision was issued. And well, I mean, to be frank with you, I don't think there is a lot of things to be said about, and that's a set-aside application. So I would say, like, from the date when you were notified, you weren't notified with the set-aside. Your answer was that you need like 6 weeks minimum to deal with that. You know what I mean? To take it from that aspect. Do you think 6 weeks is really long time for you to prepare to reply to or to even challenge a set-aside application?
The second defendant's principal position is that there is no need for a hearing to hear the set-aside application.
Well, I don't talk about here. I don't mind hearing you in paper. That's it. You're right. If you don't want to attend, you don't attend. But I said for the court to have your submission before it and then decide the case or decide the application. Why you could not say, oh, I'm challenging the set-aside application by this mean, and that's it, and then leave it for the court to decide it, even if you don't wish to attend or no one wants to attend from your side. Then it's up to you. But I said, why it's 6 weeks for you? Why you want 6 weeks from the 7th of July to be able to put a submission before the court to tackle the set-aside application? Why you think, why in your assessment, why you need 6 weeks? You said this is too urgent, but I said, why 6 weeks? Why not 4, for example? Why not 3?
With initially the responses to the directions by the second defendant was counsel was that there's Eid al-Adha, there were public holidays, there were the summer period, and I personally had pre-scheduled work commitments in the AFC courts and in arbitration, and principally my instructions in this case were not to represent the second defendant in hearings. Principally, my instructions agreed with the second defendant were to make written submissions, and if a hearing is scheduled, then the second defendant would appoint an external counsel with the necessary full rights of audience.
I understand. So from that basis, you want to have more time. Okay, I will turn now to Mr. Menz. I don't, Mr. Menz, if you still with us.
Yes, hello, my lord. I'm sorry, I've closed my video because I have some bad connection issue. And
No worry.
that's
As
why.
long as you're here, yeah.
Yes.
As long as you're here. I mean, you heard what second defendant representative have said. Are you just repeating the same things, or do you have something to add?
No, it's exactly the same position. My
Yeah.
understanding was by my previous lawyers. My understanding was that we had only 4 to 5 working days to prepare the hearing, find barrister and everything. And even me, I was a bit lost on the understanding and my instruction. And they were the summer holiday and the public holiday, who were not giving me any chance to find a barrister and to prepare correctly my defense on it.
I see. Okay, I'll turn now to Mr. Munch-Smith. Mr. Munch-Smith.
Thanks, Your Excellency. It's not correct that there's only been a couple of days to find a barrister. The direction was made on the 6th of July. That's 15 days ago from today, 16 days from the latest date that the registry listed the hearing. What I wanted to do, if I may, is just take 10 minutes and give you a little bit of background about the case. And I understand that Your Excellency has some of the background, but I just think it's important that you put this in context and get a feel for the chronology, because the case has been allowed, I'm afraid, to become something of a mess. And you are being taken for a ride slightly by the defendants on this, because this is an exercise in pure delay in the context of a very serious fraud claim. And you have the tools to put this case back on track today. It is open to you to do that, and that's what I'm going to suggest you ought to do. You'll have seen this is a claim for the enforcement of English judgment, and in that judgment, Mr. Manis was found to have defrauded the claimant of a very substantial sum, and the English court then granted a freezing order, and in its judgment for that, it found that Mr. Manis had taken very significant steps to dissipate his assets. Those steps included putting his assets into other people's hands and then pretending that they belonged to those other people. One of those assets was that in respect of one of them, which is a DIFC restaurant, that involved Ms. Zilla, his wife, or his then wife, and he's transferred that restaurant, the shares in the company, to his wife during the course of English proceedings, shortly after undertaking to the English court not to deal with that asset. Just 7 days afterwards. And so our case is that these two defendants are very clearly conspiring to try to make the first defendant look like he is insolvent, but it's all a sham. So it's important for Your Excellency to understand the degree of criminality and serious wrongdoing that we say the defendants are both currently guilty of. Part of that relates to the DIFC assets. There's been serious flouting of court orders in England, and by all accounts, Mr. Manis is someone who will stop at nothing to protect his assets from this fraud judgment. Mr. Delevka will have an opportunity to respond if he wants to in due course. But you have to consider this application in that context. We've had some asset disclosure from Mr. Manis. We say he cannot be trusted. We have no doubt that that disclosure is incomplete. So there must be a real risk that Mr. Manis is continuing to take steps to conceal his assets and put them into the hands of others. Now, a freezing order, we have a freezing order in place. And everybody says, well, that's the answer to all of this. There's no urgency here. And I'll come on to that in a moment, but it's not the answer. A freezing order only helps if either you can trust the respondent to obey the order, and we've seen Mr. Manis flout orders in the past, or alternatively, if you know where the assets are. And it only goes so far as the asset itself. It doesn't necessarily protect the value of the asset. So once we get to judgment against Mr. Manis, we'll have access to wider court powers to assist in execution. We have some protection in relation to the DIFC court share, the DIFC shares in the DIFC restaurant. But that doesn't stop dissipation within the restaurant at the level of the operations of the restaurant. So when it comes to paying out money, profits from the restaurant, we have no control over that. That remains in the control of the defendants, unless and until we can get to a judgment, at which point we can start thinking about other ways of using the wider court's powers. There is a limit on what can be done at this stage. So we need to get to judgment and enforcement quickly, and that is what the defendants are trying to prevent. And so far, with quite a degree of success, because this is a claim that started as long ago as March. And it started, as you know, with a freezing order. And we have since filed particulars of claim and applied for immediate judgment. And in the ordinary course, you would hope that this claim would be decided by now, because there's no arguable defence. Mr. Manus participated fully in the proceedings in England. He had a QC who represented him and a junior counsel as well. He was found to be a liar and a fraudster. And that is a claim which the court would usually get rid of in about 3 months. Now, parties regularly try to slow that down, and the court has, in the other cases, been very robust in resisting that. So, for example, you have the Barclays Bank case where the defendants tried to string it out with a jurisdiction application and then the immediate judgment application. The court wasn't having any of it. So now we've got to do all that in one go. And if you see it from the other side, the English court recently enforced a DIFC court judgment in Barclays Bank and Shetty. How long did that take? Looking at the judgment from that, the immediate judgment application was made on the 27th of August. The judgment in that case came in or was circulated on the 23rd of December. So that was just shy of 4 months. That is how responsive the English courts are. And so that is the sort of time frame that we would expect here. But in this case, 4 months later, where are we? Nowhere. We haven't made any progress whatsoever. And it's quite difficult to explain to the claimant why that's the case. And if the directions are set aside, that's what's going to happen. It's going to continue. And it's difficult for me to explain to court users why that is the case. And there is very strong feeling about that from the claimant's side. And the consequences we say are extremely severe, particularly of this sort of stay. Mr. Delevka says, oh, well, we can decide it on paper. It's not very important. We know what happens when cases go into the JJC. We know how long that can take. It's months. Sometimes it's over a year. Sometimes it's a year and a half. It's simply not right to say it's unimportant. And you can trace how we got here through the court's directions. But the reasons for each of those directions are very unclear. So you start with the applications to stay. They came in sequentially between the 18th of May and the 23rd of May. That's this JJC stay application. As you know, there's a very short answer to all of that. Nothing has happened in either court which counts as a decision to take jurisdiction or to refuse jurisdiction. I don't have to tell Your Excellency about the law on that because it's Lacan and Lamia. You sat on it. You know all about that. And what the Court of Appeal did there was reverse what it said was an abusive practice, which is precisely what the defendants are trying to do now. And the Court of First Instance is bound by that. Mr. Manus in his email today seemed to suggest, well, you don't need to follow the Court of Appeal. That's literally where they have to go because they can't explain why this case is different from the Court of Appeal. And that's the end of the application. There are other answers to the application, but that's the end of the stay. So that's a short application. I've done many of those. They usually last about 45 minutes, about as long as this hearing that we're having today. So instead of doing this, we could be just having the substantive application for a stay, and it wouldn't take any longer. But what happened first was that on the 10th of June, the registrar imposed a stay pending the hearing of those JJC applications. We don't know, so that at the moment, the case has stayed for that reason until those JJC applications are heard. We don't know why that's
not represented in that stay application, Mr. Mushkman.
No, that came out of the blue. I can show it to you if you have the bundle. It's at page 6 of our bundle. But basically, we just got an email saying it's all stayed.
What date is that?
10th of June 2022 came in at 8:26 a.m.
Is it who issued that order?
So it's just an email from the DIFC Courts Registry signed by Maital Shehi.
That's in the correspondence. Yeah.
We did send through a bundle of documents. Mr. Delevska said he didn't accept the documents for some reason, but we thought it would be useful to have a bundle.
Your bundle is which is your bundle is related to application number 5. Is that right?
It's related. It's 5 and 6, I think. 6 and 7. Sorry, 6 and 7.
6 and 7.
There's directions hearing bundle. It starts 10124.
And it comes under exhibit.
So it's just a PDF that was sent through, unfortunately.
Okay.
But it's just page 6 of the PDF. It's a court document. It's directions from the court in the form of an email.
Well, I'm finding terrible. I mean, finding that document. Anyway, Mr. Malik Smith, I mean, at the end of the day, I would look at the events where the registrar have received your application notice for set aside application and then wrote to the parties to be prepared to deal with it. I'm taking into account public holidays. Okay. I do remember the first email said check your availability for the hearing this date, and I do see that the email confirmed the hearing will take place anyway between 21st or 22nd of July, and then that was on the 7th of July. So 8 was the public holiday, and then 4 or 5 days, I guess, from that. Well, I would say that would give the defendant or the applicant for de novo not more than a week, where usually it's not the practice. I mean, you know, parties would need at least 2 weeks, 14 days to be prepared at least. Okay. So what they're saying things is, so it's not an agreed timetable for the hearing. If it's not agreed, and then the court or the other party would need a justified reason why this should be dealt with in expedited basis, and this is the challenge taken by the defendant in their de novo. They're referring to the matter that you have what's called freezing injection on ground intact despite the stay application, and there is no harm. Your application will be this in a couple of weeks' time from today.
Yeah, that's
from the day, from the proposed day. I mean, well, we're today. I don't know, Mr. Smith, if you, I mean, I would really try to preserve like parties' costs for support, really, and I would really need to be bound by the real urgency of the application of your case, and I didn't need to confiscate, or the court didn't need to be seeing in a position where it's confiscating someone's rights to defend and to defend in the proper way. I mean, I would really ask you if I know with your primary submission is that you're looking for tomorrow's hearing, but I can see sort of difficulties. I would ask you if you have a solution in mind coming to this hearing, Mr. Malik Smith. Okay.
The solution is
if you have another alternative solution,
the solution is we can do any day next week. That's the solution. We can do any day next week.
So you can give another week for the defendant.
So we can give one more week. I think Mr. Delevska said he wanted to simultaneous exchange of submissions on Tuesday next week.
Mm-hmm.
And then the only question is then, do we have a hearing next week after that?
I think their position is they want to do on paper, they don't want to attend. They want to just send the submission to the court and the court to decide.
That's their right. And if they don't want to attend, they don't have to attend. I would like to be able to attend because I've seen what happened in the past. So we've seen the decision that was made on paper by the judge. It's inconsistent with the Court of Appeal authority. It's obviously wrong.
What's it? Mr. Delfica, what do you think of 1 extra week?
The claim, the second defendant's
for your submission, and the court would deal with it on paper as you wish.
The second defendant stands by its proposal to make simultaneous written legal submissions by Tuesday, the 26th of July 2022, 4 p.m.
Okay,
and
Tuesday.
sees absolutely no reason for a hearing. The claimant has already filed 4 individual responses for 4 individual stay applications.
Right.
Over a course of 2.5 months that's been ongoing. And upon review of all of these submissions, the order to stay was issued. It wasn't the email for the temporary stay of the 10th of June 2022, but there was an actual order upon review of all of the 4 submissions, including the claimant's submissions.
That's not accurate. We didn't make any legal submissions on the
I didn't say
JJC
legal
application.
submission.
Well,
I said submission.
I'm focusing on the solution
That's
rather than the
misleading then,
problem.
Mr. Delevka.
Factual
Yeah.
submissions.
No, it's
Yes.
misleading, Mr. Delevka.
Well, Mr. Smith, I'm focusing on the solution.
I understand.
The problem.
Can I just make? I mean, I haven't
But
actually
it's a
answered
beauty.
the
Okay, Mr.
application.
Delfico has agreed to submit to put
Yeah.
his submission by Tuesday.
Yeah.
And then you can maybe, if you want to answer or if you want to appear and defend it orally, their submission, and that could be easy. We can do it the next Friday, and then at the end of the day, and we will see Mr. Men's position if he agreed to that, and then we already are accomplishing your suggestion by dealing with the case next week, Mr. Men's. Mr. Men's.
Yes.
Yes, thank you. Thank you very much, Your Excellency. But I'm a bit I agree completely. If it's possible to make the hearing on paper and to make written submission, because my understanding is that there is no urgency, there is no need of a hearing and an urgent hearing. There is a freezing order in place. Nobody's touching any assets of the freezing order, and I have clear advice that there is a conflict of jurisdiction, and that there is decree. So that's
Mr.
why
Manis,
I believe.
sorry to interrupt. If Mr. Manis is going to make representations about what his advice is, he needs to be aware that he's thereby waiving legal privilege. So I need to warn him as to that. Going forward, if you're going to tell us what your advice is, Mr. Manis, the result of that is that you're going to have to show us your advice.
I agree.
So
Mr.
be
Manis,
cautious.
stick to the timetable. Stick to the timetable. If you
Yes.
can write, if you can submit any writing defending the set-aside application by Tuesday, likewise,
Next Tuesday.
Mr. Delfica do it, and then the court will deal with it on paper, and that's all.
Thank you very much.
Would
Thank
you,
you very
would
much.
you be able to do that?
I will do my best, and I will do my best. I will do it.
Okay, so Mr. Smith, we have both parties unwilling to submit their defense to your application, to set aside Justice Maha's application to stay the proceeding. And then it's what's left is how you want us to deal with your submission and reply, whether by orally or you want to submit a written submission against both application and the court deal with them in paper. And I can assure you we can provide a very speedy judgment within 1 or 2 days.
Thank you.
From your submission. If you want to do it orally, if you want to do it, it's up to you. The principle in this court, if someone insists he needs to be heard, then he has to be heard.
Yeah.
If you want to let that go, and if you want to reply in submission, and the court will deal with it exactly as you submitting orally, and then we would deliver a very quick judgment. And if we think the reason would take longer, we would just deliver the decision and the reasons to follow.
So thank you, Your Excellency, and I understand that, and I'm fortified by that. I think that our priority is one, speed, but also clearly the concern that arises is simply that the order was made in the first place. Now, in the ordinary course, we would have thought that was obviously not something that this court would do. It's an absolute outlier. It's not happened since the Court of Appeal decision in Lacan. And so
well,
the
we
concern,
didn't have to go to the merit of the application. No, Mr. Smith.
I know, but
the time frame.
Yeah, the concern is just that if there is a problem that the court perceives with my application, I just want to be able to answer it. I want to, and what matters is what's in the judge. I don't know
But
whether
you're
it'll be
having
your
the final
excellency.
round. You're having the final round, Mr. Mundik Smith. You apply, they reply, you reply to them. That's the end of the story.
Yeah, the question is how.
The way we work, you want to submit it by written submission, or you want to appear before the court.
If it can be accommodated
I'm
next
giving-
week, I think our preference would be to appear. But I will, if you give me 5 minutes or 2 minutes even, can I just wait for some instructions on that?
Yes, I can give you that. Okay, we'll take a break for 5 minutes and I will be back.
Thank you.
Thank you.
Yes, we're back.
Your Excellency, thank you very much for that. My instructions are that my client would prefer to have a short hearing if that is possible, if it can be accommodated next week.
Yes, well, if you insist, I don't think I told you what is my principle in this court. Is if someone wants to be heard and has to be heard, and the other parties, up to him. If he want to abandon, then right.
Understood. Thank you. As I say, I mean, it's a balance between wanting to get our points across and timing.
And
because
would you put a written submission too? I mean, would you? I mean, you would
Yes, that would
reply
help.
in writing, and then you would come to the court to say it out loud.
yes, just to deal with any problems that you may have with what I've written down. If that's probably the quickest course. If you agree with what I've written, it'll be a very short hearing indeed.
If I give you that right, I would still make it free. I will deal with it and be able. I will listen to you for short hearing. I mean, in your own cost for appearing, you, Mr. Mundik Smith, for the appearing, if you wish like to do it. But I would keep it open if any of the parties wants to come on record that day, and then I will try to see whether costs need to be determined.
Understood.
Make sense?
Understood. Thank you.
Then, so Tuesday, the deadline for defendant 1 and 2 to put their submission tackling or defending the set-aside application. Within you will, I would have your submission 1 day before the hearing. That means Thursday, Mr. Mundik Smith.
Yes.
The hearing would take place at 11 a.m. Dubai time on Friday.
Understood.
And what I'm looking for, cost in a case.
Understood.
Is that clear, Mr. Zilivka?
Yes,
Are we
it
clear?
is, Your
Yes,
Excellency.
Mr. Mans?
Yes. Well, I'm grateful.
Yes, thank you.
Yeah, please do your best. Do your best to that we have your written submission against the set-aside application.
Okay.
Thank you very much for appearing. Thanks for your collaboration.
Thank you, Your Excellency.
Thank
Have
you.
a
Your
good day ahead
Excellency.
all. Thank you.
Have a good day. Goodbye.